Most patents don't die because the science is bad. They die because someone talked too soon. About 65% of patents that are invalidated in court fail because of a public disclosure.
The best way to avoid this is with an NDA. Today, we're talking about non-disclosure agreements, or NDAs, and how they protect your technology before you file a patent. Here are the three most important things you need to know about NDAs. First, you need an NDA anytime you plan to disclose your technology outside your company. Second, NDAs help protect your patent rights. And third, NDAs control what the receiving party can do with your information. At their core, NDAs are legal agreements that protect confidential information between parties. Many scientists think of NDAs as boring paperwork, but if you ever experience a serious confidentiality breach, you won't think they're boring anymore.
About 65% of patents that are invalidated in court fail because of a public disclosure. A paper, a poster, a pitch, a presentation, something that went public before the patent filing.
The best way to avoid this is with an NDA. So a little knowledge now can significantly reduce the risk of a very expensive mistake later. While NDAs may not be the most exciting topic, they play a critical role in protecting valuable intellectual property, especially in the life sciences. You may also have heard NDAs called confidentiality agreements or secrecy agreements. These all refer to the same thing. It's the same agreement. NDAs can be mutual or one way. Mutual NDAs protect information shared by both parties. One-way NDAs protect information shared by only one party. In most cases, scientists and startup founders should use a mutual NDA. Mutual agreements encourage open discussion and set the tone for a professional relationship where both parties recognize the value of confidential information. One-way NDAs have their place, but they're less common early in a collaboration. When do scientists need an NDA? You should use an NDA anytime you disclose your technology outside your organization. This includes discussions with potential collaborators, research partners, potential investors, testing laboratories and vendors, or even service providers. One important exception, disclosing to an attorney, is protected by the attorney-client confidentiality provision, even if you ultimately decide not to hire that attorney. Now, let's talk about why NDAs are so important. First, NDAs create an enforceable legal obligation. NDAs are contracts, and contracts can be enforced in court. This matters most when your patent hasn't issued yet. Patents can take years, but an NDA gives you immediate legal protection if confidential information is mishandled. Second, NDAs help preserve patent rights. Public disclosures or sale of an invention triggers patent filing deadlines. In the United States, you typically have 1 year from public disclosure to file a patent application. Disclosures made under an NDA generally do not trigger that deadline. Outside the United States, it's even trickier. Many countries follow an absolute novelty rule. Public disclosure before filing can permanently destroy patent rights. Because life science inventions often have global potential, NDAs are critical to preserving international options. And third, NDAs control how your information is used. NDAs can restrict who may access your data, how it may be used, whether it can be published, and who owns the intellectual property that's created during the relationship. Now, physical samples are often transferred under material transfer agreements, or MTAs, but sometimes samples are shared under NDAs. And in those cases, ownership of data, publications, downstream intellectual property should be clearly addressed in the agreement. Before we wrap up here are a few common NDA mistakes scientists and founders make. Number one, signing the party's NDA without review. If you receive an NDA from somebody else, don't just sign it, review it. Don't assume that all the clauses in every NDA are the same. They're different, and those differences can make a difference. Number two, assuming that a verbal NDA or email language is enough. Number three, forgetting that NDAs often expire. You need to keep track of your deadlines and know when the agreement goes out of effect. It can be very important if a company that could compete with you has your technical information and then the agreement expires and now they can use it publicly for their own purpose. Failing to write and mark information as confidential when required. So a lot of confidentiality NDA agreements require that the information be confirmed in writing. And so you need to send a follow-up email summarizing the discussions. This is especially easy now because there's a lot of transcription programs out there, and you can take the transcript and summarize it and then just say, here's the confidential information. Number five, disclosing information before the NDA is signed. So it's often tempting when you're in the early stages of a relationship and you want to show the investor or the company what you've got. Make sure that if you do share a deck, it's a non-confidential deck, and then you can go back and sign an NDA later. Any one of these mistakes can seriously undermine confidentiality and patent rights, and you can end up being one of the 65% of patent holders whose patents are invalidated because they did a public disclosure. Can NDA mistakes be fixed? Well, sometimes, but it's far better to avoid them in the first place. In limited situations, parties may confirm confidentiality in writing after the fact. That's better than nothing. Or you can sign an NDA that applies retroactively to an earlier disclosure. This is even better. You want to avoid backdating signatures, but you can structure the agreement so it covers discussions that took place in the past, even before the date that the agreement is signed. These steps may help create a legal argument later, but they are no substitute for having the agreement in the first place. And whenever possible, you should file your patent application before disclosing your invention to third parties, even if it's just a provisional application filed with your slide deck, or your poster presentation. Getting something on file that can serve as a placeholder for priority is also an important way to protect yourself. But, every situation is different, and confidentiality mistakes can be costly. And if you're unsure about whether you need an NDA or whether a past disclosure could be a problem, it's best to speak with an experienced intellectual property attorney. This is Patent Science, helping life scientists protect innovation from the lab to the marketplace. I'm Richard Gearhart, and we'll see you again soon.